Good afternoon and welcome to the National Resource Center, Department of Mass Communication and Journalism, Tezpur University, Assam. During the last session, we discussed about the ambit and the scope of cyberspace, various issues and dimensions to that. In this particular class, we intend to look at the regulation of the cyberspace and cybercrime as a phenomenon in India. Before we look at the whole regulation or the regulatory aspect of the cyberspace, let us understand what are the fundamental characteristics or the salient features of cyberspace. As we have already understood that this is a space which is different from the physical space in terms of jurisdiction, in terms of geographical boundaries, and in terms of other legal issues and concerns. As you all know, there is no fixed territory or boundary in case of cyberspace, unlike what we have in case of physical space. It exists through mobiles, cables, computers, etc. The key to this world is password and the stored electronic data. Laws and regulations that we are going to discuss today are national, whereas the territorial jurisdiction of cyberspace is something global and universal. Moreover, the issues of culture and morality also varies from place to place, country to country, region to region, but cyberspace does not take into consideration all those aspects too. Now, it is also difficult for a person to ascertain where from a particular email has originated. Also, it is difficult for somebody to ascertain where from a particular crime being committed. It may so happen that a particular crime was committed from a place, from abroad, say for instance Australia, and the person who has committed the crime may be residing somewhere in Australia, but the victim may be somewhere in India. Because of that, the courts in India have also found it very difficult to hear a particular case because of lack of competent jurisdiction. In cyberspace, it is difficult to ascertain in certain terms the applicable laws of a particular country and jurisdiction to that effect. Because as I have already told you, that particular crime might have been committed in Australia, but the victim resides in India. Because of that particular difficulty, it is for the courts, again it becomes a complex issue altogether. The laws of which country, Australia or India for that matter, will be applicable in a particular cause of action. What also happens is that because of anonymity of the internet user and absence of geographical boundaries in the cyberspace and the cross-border effect of internet transaction, all legal systems, irrespective of any country, face legal uncertainty. Multiplicity of overlapping applicable laws and jurisdiction, multiple and contradictory regulations, and at times we may also say no regulation at all. So from the discussion that we are having now, perhaps you are getting some idea about how difficult it is to regulate the space called the cyberspace, which only exists in kind of through computers or the internet and other devices. This is something, it has got no territory, because if you look at the Indian laws, the first or the second section of a particular legislation starts with the whole thing of territorial jurisdiction. But in case of cyber offenses or the cyberspace, there is no territory at all. We cannot say that a particular law will be applicable only to to, it's applicable to the whole of India except J&K and the tribal areas, as we have in different laws, it starts with that. But in case of Information Technology Act or in terms of any other legislation for that purpose, enacted for the purpose of regulating the cyberspace, we cannot have such fixed territorial jurisdiction. In this particular backdrop, what we need to understand is the cyber law. As we all know, cyberspace is governed by a system of law and regulation called cyber law, encompassing all aspects of transaction and activities concerning the internet, the World Wide Web, and the cyberspace. Looking at the Indian scenario, looking at our own country, the emergence of the cyberspace necessitated the enactment of cyber laws in India, as the old laws were not sufficient to address the different issues and concerns and constrain the new problems arising out of the cyberspace. The General Assembly of the United Nations adopted the United Nations Commission on International Trade Laws, that is the model law on electronic commerce, on January 30, 1997. And India being a signatory to that, it had to bring suitable amendments in the existing laws as per the said model law. In Indian Parliament, under Article 253 of the Constitution, relying on the resolution of the General Assembly of the United Nations, passed the India's first cyber law, that is the Information Technology Act 2000. However, in the aftermath of the 26/11 Mumbai attacks in November 2008, the Indian Parliament passed the Information Technology Amendment Act 2008, incorporating necessary requirements like the cyber terrorism within the ambit of the Information Technology Act. However, the fact remains that the Information Technology Act primarily was brought in for the purpose of facilitating e-commerce and e-governance, and matters such as cyber crimes were not the primary objective of this particular legislation. Now, the Information Technology Act was in the news in 2015. It is always, most of the times it is in news, but in 2015, there was a very important case of the Supreme Court. The Honorable Supreme Court struck down Section 66A of the Information Technology Act 2000 as unconstitutional on a writ petition filed in the case of Shreya Singhal versus Union of India. The repealed Section 66A prescribed punishment for sending offensive messages through communication service, etc. That is what we understand in general parlance as online defamation. What exactly happened in this particular case? I think it will be very interesting for the media educators and the journalists and the other mass communicators. I'm sure most of you know about this particular case. But then what exactly happened was, concerned by the recurring arrest being made under Section 66A, repeal section, this was a part of the Information Technology Act. A petition was filed in the public interest before the Honorable Supreme Court, challenging the constitutional validity of Section 66A. The petitioner in this particular case argued that this section is too broad in its sweep and contains several undefined words, terms, making it kind of susceptible to wanton abuse. This creates a ceiling effect where citizens are severely harassed from exercising their constitutionally protected right to free speech for fear of prosecution. Thus, this particular Section 66A is violative of Article 14, 19, and 21 of the Constitution of India, which guarantees citizens the fundamental right to equality, free speech, and life, respectively. So, in this particular case, the Supreme Court, they relied on a lot of important kind of arguments which were placed in favor as well as in against this particular contention, and finally Supreme Court agreed upon the fact that this perhaps section was perhaps unconstitutional, and finally it struck down this particular section. After this discussion on this particular regulation and the regulatory aspect of the cyberspace, let me take you to the world of cybercrime. Now, what is cybercrime? I think in the last discussion that we had, we tried to understand to some extent what this phenomenon is all about. Now, as I have already told you, that for the purpose of an offense or the crime to be called as a cybercrime, what is important is that the particular device or the computer needs to be attached with or needs to be connected with the internet. Without the internet being connected to the device or the computer, if a particular offense happens, the particular crime is committed, we cannot call it a cyber crime. We can at the most call it a computer crime. Now, if you call it a computer crime, this also brings forth what is computer crime. Now, computer crimes are essentially, they can be classified in two headings, where number one, computer is either a tool, and number two, where computer is a target to perform unlawful act. So, on the one hand, you have cybercrime, where computer is being used as a tool by connecting it to the internet. On the other hand, a computer can also be the target for the purpose of stealing some important information from a particular hard disk. That is why you must have seen that in many of the important government departments or the departments which are handling some sensitive information, they do not connect all their computers to the internet, because there is a fear that any information may really be going to wrong hand. At the same time, despite all that, there may be some attempts to steal some information even if the computer is not connected with the internet. And when that particular thing happens, when somebody tries to get some important data or sensitive data from a particular computer system or device, that becomes a computer crime. Whatever may be the definition and the perspective for the purpose of looking at cybercrime or computer crime, we must be very clear that this cybercrime is something very emerging, something very important phenomena in today's context. Now, when we talk about cybercrime, what are the most important, what are some vital and the prominent cybercrimes which have been reported in India? I have already narrated one example, that's online defamation. There's something also called cyber pornography. There is publishing and transmitting obscene material in electronic form, criminal liabilities of intermediaries, and computer-related offenses within the meaning of definition given in section 66(5) and 66 of the Information Technology Act 2008. Now, if these are the cyber crimes, what are the cyber crime related legislations in India? Now, when you look at the cyber crime related legislation in India, the Information Technology Act is the primary legislation. Even then, the Information Technology Act nowhere uses the words cybercrime. It has only has a particular section devoted for the cause of offenses. They are not calling it cybercrime, they are calling it offenses. But other than the Information Technology Act also, there are provisions in the Indian Penal Code, the Indian Evidence Act, the Criminal Procedure Code, Bankers Book Evidence Act, the Companies Act, Reserve Bank of India Act 1935. Now, all these acts were also subsequently amended after the enactment of the Information Technology Act. So, when you call it cyber crime related legislation in India, it's not only the Information Technology Act, notwithstanding the fact that it's the primary legislation, but the other laws are also directly or indirectly dealing with the subject of cybercrime in India. Friends, as I have already told you that in 2008, the Information Technology Act was amended, And with these amendments, some of the new provisions were inserted, and subsequently a paradigm shift came in terms of changes which were brought in the substantive and procedural laws as well in India. The specific provisions in the Information Technology Act after the amendment of 2008, which contain provisions relating to cyber crime, are numerous. There are many. There are sections from 43 capital A to kind of 84C, and also the subjects being the things like the cyber terrorism. Then you have the things like online defamation. Then you have the things like publishing and transmitting obscene material in electronic form, and so on and so forth. When you look at the kind of cases which are being reported in India, so far as the cyber crime is concerned, the first cyber crime case decided by the court in India was related to Dr. Prakash, L. Prakash, a doctor, imprisonment for life in a cyber prawn case in February 7, 2008. Other landmark cases also, as I have told you, one is the Shreya Singhal, where the Indian Supreme Court has struck down section 66A of the Information Technology Act. Now, Arif Azim case, the Suhas Kate case, the Baji.com case that I am going to look at today, Sanjay Kumar Kedia case are some of the important cases being dealt by the Indian courts under the Information Technology Act. As we have already seen, the Information Technology Act covers some of the cyber crimes, yet it is not a comprehensive legislation for that purpose exclusively devoted or related for the purpose of cyber crime in India. Cyber crime in India, though it's increasing or rising day by day, it remains a neglected area in jurisprudential growth, and much work needs to be undertaken towards the direction. Well, different varieties of cyber crime when it comes to, we have seen the Shreya Singhal case where the online defamation being a matter of concern. We also have the very important case Avnish Bajaj versus State. It's a Delhi High Court case where the criminal liability of the intermediaries, it was a concern. Now, when a particular student posts a particular item, a MMS video clip for sale in the website which is being owned by a different person, and this contains some of the item, and this particular video clip, it was named as item 278777408 DPS girls having fun. Full video Debajit.com points. The item was listed online around 8:30 p.m. in the evening of November 27, 2004, and was removed around 10 o'clock the next morning. The crime branch of the Delhi police took cognizance of the matter and registered an FIR. Upon investigation, a search sheet was filed showing Ravi Raj, the person who actually did the whole incident, and Avnish Bajaj, the owner of the website, and another person, they were guilty of having committed this particular offense. Now the point is whether the person who was owning that particular website, where this particular content of or the MMS was posted, could be held liable. Now court held that in this case, yes, though not under the Indian Penal Code, but in the Information Technology Act, this person was held liable or responsible. Now there is another case which is very interesting. There are so many cases which are being reported, but then for the purpose of our understanding, for the purpose of the media educators and the journalists, we are only trying to look at some of those. Now another thing which usually comes up is the tampering with computer source documents. Now what is that computer source documents? There could be some important information. Whoever, it says that whoever knowingly or intentionally conceals, destroys or alters any computer source code used for a computer program, computer system or computer network, when a computer source code is required to be kept or maintained by law for the time being in force, shall be punishable with imprisonment up to 3 years or with fine which may extend up to 2 lakh rupees or the both. Now, the point here is that what is that computer source code, or what is that important computer source document? Now, there is a very important case which was reported. This is Syed Asibuddin and other versus the state of Andhra Pradesh. In this case, the Tata Indicom employees faced surges of hacking with computer source code under Section 65 of the Information Technology Act for manipulating the electronic 32-bit number programmed in cell phone which were to be used only on Reliance Infocom service network. Now, what exactly happened was that in this particular case, the court held that tampering of that particular code amounts to tampering with the computer source code, and it will not be some fair dealing, but it is something which is punishable under Information Technology Act. Now, the point I am trying to bring to your notice here is that even a code for that matter may amount to computer source, something to do with the tampering with computer source, or what we call it, tampering with computer source document. Now, many of you, or I think most of you, have also heard about the word called hacking under the Information Technology Order. What is hacking? Phishing, hacking, these are the words that we usually come across when it comes to cybercrime. Indian courts have dealt with few cases of hacking, and one important case which I would like to discuss today is Abhinav Gupta versus State of Haryana. Now, what happened in this case was the petitioner was accused of hacking confidential information, confidential drawings and design plans of his former employee while in his employment. Now, what this person did was, he had allegedly and intentionally provided the confidential information to the competitor of his earlier employee. Now, how he did was, he first passed on the information to his personal email address, and eventually he forwarded the particular information to the present employer or his subsequent employer, who happens to be a competitor of his former employer. In this particular case, the High Court and the High Court of Punjab and Haryana examined the definition of hacking under Section 66 of the Information Technology Act and found that the petitioner had transferred confidential information during his early employment to his personal email address and later disclosed the same by forwarding it to the email box of the competitor, which he joined later. Now, the person was held liable for it, because when he was sending, or when he was trying to send confidential information to his own email address, that particular act he was not doing in official capacity, he was doing it in personal capacity. Now, after that, the same information was forwarded to a particular employer, his subsequent employer, who happens to be a competitor of his former employer. So, this was a clear case of hacking as the court interpreted it. Now, there is another word which usually comes in cybercrime is the phishing. Now, what is this particular phishing all about? It is primarily a kind of financial crime wherein the cyber criminal, they poses as a genuine party such as a bank, and steal sensitive financial information from the victim, and for the purpose of defrauding him and also to make wrongful gains out of it. In one of the important cases, the National Association of Software versus Ajay Sood and others, the court explained the meaning of phishing as a cyber crime, where the criminal use internet and computer for to cheat the honest and innocent people by asking from them some of the important personal information relating to their banks and other financial transactions. And in the process, they try and misuse that, then try and steal their financial capacities, and they try to cheat them in the process. Now, in this one particular case, that's Ranjit Udesi case, the petitioner filed a case for claiming compensation under Section 43 of the Information Technology Act, and he was made a victim of phishing attack from an email that appeared or seemed to have been sent by his bank requesting him to update his personal account data. When the bank contended that petitioner was negligent, the adjudicating authority took the view that bank did not adopt due diligence measures to make its banking system more secure. Now, the whole point in the Ranjit Udesi case was that whenever the financial information are being sought from any person for that matter, by making use of the internet, that particular information can be manipulated and people may take undue advantage out of that information which is being transferred or which is being given. And because of that, whenever some people try and take undue advantage of that, that becomes a clear cut of what we understand by the word phishing. Now, there is also very important cybercrime which is very common, is the publishing of obscene material on the internet. Now, is it permissible? Is it all right to publish obscene material on the internet? Now, the Information Technology Act lays down that it is an offense, and some of the important cases that are being reported, I would like to talk about one case, that is Dr. L. Prakash and others versus State, wherein court sentenced the accused to imprisonment for 2 years for publishing obscene messages against a divorcee woman in a Yahoo message group. Emails were also forwarded to the victim by the accused through a false email account opened by him in the name of the victim. The posting of the message resulted in annoying phone calls to the lady in the belief that she was soliciting. Now, this particular person was convicted under the Information Technology Act, under the various sections, and this was a very good case of what we say the publishing obscene material on the internet. Now, whatever I have discussed today with you friends is some of the cyber crimes which are very common. There are other cyber crimes too, which perhaps time does not permit us to discuss or talk about today. But what I strongly believe is that from this discussion, all of you have some elementary understanding of how the cyberspace is being regulated, and when you fail to regulate it, how people may take undue advantage of the cyberspace because of different factors which favors the criminal. Well, what I intend to tell you here is that whatever the different cyber crimes that I have narrated today, these are only a few of the cyber crimes. It is not the exhaustive list of cyber crimes. But what perhaps I wanted to make you understand here is that the whole ambit of cyberspace is so wide, and so is the ambit of cyber crime. It is expanding, it is increasing, and we as a nation has to really think about not only legislative measures, but also through other measures to contain the cybercrime and to have a very strong regulation over cyberspace. With this, I would like to thank you all for your patient hearing. Thank you.